Mr. Hernandez has certain obligations,
Yes, sir.
and the other party has certain obligations,
They do.
and they are enforceable at law.
Yes, sir.
You also negotiated endorsement deals for Mr. Hernandez,
Our agency did. Yes, sir.
and you are the president of the agency.
Yes, sir.
So when you say our agency did, is that meant to indicate that some of your associates might be sort of the first line?
Yes, Aaron had several endorsement deals when he was playing in the NFL, and a number of different people in our office would negotiate different deals. But I was involved with all the negotiations as a president. Yes, sir.
Now, just briefly for the record, how would you characterize an endorsement deal? What is it?
An endorsement deal is where a company will pay a NFL player in exchange for their name and likeness, and maybe require some conduct on their behalf, like attending a cocktail party or a charity event or something like that.
These deals usually were reduced to writing, correct?
Yes, sir.
In the form of a contract
Again, yes.
that Mr. Hernandez signed
Yes, sir.
and that the other party signed,
Exactly.
and you would review the contract with Mr. Hernandez,
Prior to him signing the contract, we review all the contracts, yes.
and you would talk about the things that he wanted to be included in the contract,
Yes, we would.
including compensation.
That was a big part of it, yes.
You also negotiated marketing deals for Mr. Hernandez, correct?
Yes, sir.
And can you tell the court what marketing deals are?
Well, marketing deals and endorsement deals are pretty much the same thing.
They too are reduced to writing
Yes, sir.
in the form of a contract
Yes, sir.
that each party signed.
Yes, sir.
I want to draw your attention to the name Alexander Bradley. Do you recognize the name?
I do.
You've never met Mr. Bradley, right?
I don't believe I have.
In person.
I don't think so.
But you first heard, to the best of your recollection, you first heard about Mr. Bradley through your then client, Mr. Hernandez.
Yes, sir.
Mr. Hernandez showed you a series of text messages that you were told were from Mr. Bradley.
Yes, sir.
And these were text messages from Mr. Hernandez's cell phone.
Yes, sir.
Drawing your attention to a specific set of messages, you read some messages that you perceived as threatening to Mr. Hernandez.
Yes, I did.
You read text messages that threatened to sue Mr. Hernandez.
Yes, I did.
And you read text messages that threatened to take all of Mr. Hernandez's money.
Yes.
These messages, your understanding, were that these messages were from Mr. Alexander Bradley.
That was my understanding.
You were concerned, it's fair to say,
I was.
concerned about possible litigation.
Yes.
In the text messages you read, you saw a threat to a civil lawsuit.
Yes, I did.
You were concerned because whether the allegations were true or false, a civil lawsuit would be injurious to your client.
Yes, that was part of my concern.
They would harm your client's brand.
That was part of the concern, yes.
And part of the concern as well was that it could impact endorsement deals and the like.
I was more concerned about Aaron Hernandez as a person than I was the commercial deals and endorsements.
Right, we're getting to that
Okay,
next.
yeah,
But that's part of the concern.
Yes, yes, sir.
And you, when you read the allegations, you did not believe them.
No, I did not.
That was not consistent with the Aaron Hernandez that you had known for 4 or 5 years.
Not at all.
Now, as his agent and representative, you wanted to, one of the things you wanted to do was to avoid litigation.
Yes,
You did not want a lawsuit to be filed, is that right?
that's correct.
In an effort to avoid litigation, you made a telephone call to Mr. Bradley's lawyer.
I participated in a phone call to Mr. Bradley's lawyer. The phone call was actually made by my general counsel, Mark Humanick.
Both of you were on the call together.
Yes, sir.
So you're saying he actually dialed the number.
Yes, sir.
You participated in the call with Mr. Humanick.
I did.
You spoke with,
Hold on, counsel, 1 second. Could you spell Humanick, please?
Sure. It's H-U, M as in Murphy, E, N as in Nancy, I-K. Humanick.
thank you, Your Honor. So you participated in the call with Bradley's lawyer.
I did.
And you had, with Mr. Humanick, initial settlement discussions about the proposed lawsuit.
We did.
The two of you wanted to figure out whether there was a potential monetary settlement that could be made prior to any lawsuit being filed.
Yes, sir.
And when you have Mr. Humanick on calls with you, and I'm speaking generally now,
Yes, sir.
you consider those calls to be attorney-client protected?
Yeah, I would. Yes, sir.
The objection is overruled.
He was on that call, Mr. Humanick, to be clear, with you and Bradley's lawyer.
Yes, he was.
Now, without going into any substance about the call, it's fair to say that the call did not result in a settlement.
That is true.
When the call did not result in a settlement, you decided to turn the case over to another set of civil lawyers,
Yes.
or to a set of civil lawyers.
Yeah, we were gonna, just to clear, we were going to turn over to those lawyers either way. I mean, even if we had reached a quote-unquote settlement, we would pass that. We were going to pass the results of that conversation onwards to Ropes and Gray, no matter what the result of the phone call had been.
So you mentioned Ropes and Gray. That's the law firm that you turned the matter over to.
Yes, sir.
Now, I imagine that when the settlement, when no settlement was reached, you didn't take the yellow pages, put them in front of Mr. Hernandez, and say, "Hey, go find a lawyer," right?
We did not do that.
You didn't put them in front of your computer and say, "Google civil law firms and go get a lawyer to handle this," right?
Correct.
You suggested that he speak with the lawyers at Ropes and Gray.
I did.
You had worked at Ropes and Gray.
I had.
You knew lawyers at Ropes and Gray.
Very well.
You called Ropes and Gray prior to Mr. Hernandez being in touch with them.
I did.
You spoke with Ropes and Gray about the settlement discussions.
I did.
You spoke to Ropes and Gray about the text messages.
I did.
There came a point in time when you attended a meeting with Mr. Hernandez and his lawyers at Ropes and Gray.
Correct.
You were in their offices, correct?
Yes,
And you went to a conference room.
we did.
Now, when you got in the conference room, did you have any discussions with Ropes and Gray about whether it was appropriate for you to be in the room?
We did.
And can you please tell the court the nature of those discussions?
Sure. As you mentioned before, when I left Boston to go become a sports agent, I did not have to be an active attorney anymore, and I was not going to take the California State Bar. And so I did not keep up with my bar in Massachusetts. I probably should have made it inactive as opposed to just ignoring it. But because I was not active lawyer in any state, when I attended these conversations with Aaron and his attorneys, I wanted to make sure that I was not disrupting or breaking the attorney-client privilege, and that it was okay for me to be present in the meetings. And what I was told was, just like a paralegal or any other member of a law firm who's not an active attorney, my presence at the meeting would not, in fact, violate the attorney-client privilege, or it would still be protected.
So, as you sat there is it fair to say that you considered the contents of, or the discussion at these meetings as protected by the attorney?
100%, or I would have left.
And as you sit here today, you feel the same way?
Absolutely.
Now, I'd like to turn your attention to the cell phone itself, Mr. Murphy. So, Mr. Hernandez showed you these messages on his cell phone. Showed you these messages that we referenced from Alexander Bradley. He showed them to you on his cell phone.
He either I don't know if he showed them to me on his cell phone. I think he forwarded them to me. I don't think Aaron and I were in the same place.
That's my mistake. But they were cell phone text messages.
Yes, sir.
Now, without going into substance, at some point you had a discussion with Mr. Hernandez about taking his cell phone to Ropes and Gray.
Yes, sir.
Now, when you spoke with Mr. Hernandez about the text messages and the cell phone, you also offered some advice with respect to his participation in the text exchange.
I did.
And what was that advice?
I told him not to return any texts.
You were concerned that you didn't want a war of text record.
Yeah, the text message.
Well, Mr. Sullivan, you have had quite a bit of latitude with leading questions. So if you would, don't ask leading questions. And I will tell you, I would find it helpful if we put some time frames on some of the testimony.
Well, absolutely, Your Honor. I'm happy to lay a many question foundation for every question. In light of last hearing, my only effort was to move the calendar along.
I appreciate that, but on objection, I think it is a well-put objection.
Very well, Your Honor. And so my last question, Mr. Murphy, had to do with the advice you gave, and I couldn't tell whether the court reporter, whether you answered or not. But did you offer any advice with respect to what Mr. Hernandez should do with regard to the text exchange?
Yes, I did.
What was it?
My advice to Aaron was, given the serious nature of the text messages he was receiving, to let the attorneys handle it and to simply not respond to the text messages.
Did there come a time as well where you asked, where Mr. Hernandez sought your advice with respect to what to do with the phone itself?
Yes,
Did you offer any advice?
I did.
And was all this advice still in the context of this pending potential civil litigation, the serious nature of the civil litigation that you just testified to?
I believe the advice was offered during the meeting at Ropes and Gray.
And the advice, essentially, without going into any detail, was in terms of what to do with the telephone?
The advice as to what to do with the telephone came from the attorneys, and it was to turn over the cell phone to the attorneys.
And so this was at the meeting at Ropes and Gray?
Yes, sir.
This was the same meeting where you raised the question whether it's okay for you to be present?
Yes, sir.
It was at this meeting that Mr. Hernandez was advised to let the lawyers at Ropes and Gray have physical custody of the telephone.
I believe so. That's my best recollection. It's been a little while, but I believe that's where the advice came from.
Court's brief indulgence. just a couple more minutes, Your Honor, in actual time,
Okay,
not lawyer's time. Just to put a time frame around this, and I know this was a long time ago, and you may or may not remember exact dates, but
Sure.
these occurrences that you testified to occurred prior to you testifying in the grand jury.
Yes.
One more area, Mr. Murphy. At some point, you and Mr. Huminick received a letter from Ropes and Gray, and it was a letter that had to do with you assisting, with you and your firm assisting with the representation of Mr. Hernandez.
Yes.
Do you recall the letter I'm speaking about?
I do.
Now, there's some question about whether you two signed the letter. Do you recall signing the letter?
I don't recall signing the letter. No, sir.
Do you recall not signing it?
I do not.
So you, in other words, do you know whether you signed it?
I do not know if I signed that letter.
Do you have any reason why you would not have signed it?
No, I assume that I did sign it, but I just don't have any recollection of that.
Did you assume that you were bound by the representations in the letter?
Absolutely.
And can you just tell the court briefly your memory of what the letter stipulated?
I believe the letter was from Michael Fee, who was an attorney at Ropes and Gray, and basically it was reinforcing what we had talked about at the meeting, whereby Mark Huminick and I would be part of the Aaron Hernandez legal team, Mark as an attorney and myself as a representative, and that we would be held to the same standards as all of the attorneys, and that we would have to protect the attorney-client privilege just like an attorney would, and basically that we were part of the legal team, even though for me personally I was not still a practicing lawyer.
And did you conduct yourself in accord with that understanding?
I did.
Nothing further.
So that I am clear, Mr. Murphy, you said that Mr. Hernandez sought advice about what to do with the phone. And then you said that the attorneys provided advice about the phone, that is, to turn it over.
Yes, sir.
And that was at the meeting where you discussed the attorney-client privilege issue, is that right?
That's correct, sir.
And just so that I have it straight, how many meetings were there at Ropes and Gray between you, Mr. Hernandez, and attorneys at Ropes and Gray?
I believe there's one.
One single meeting.
Yes, sir.
Thank you, sir. Commonwealth.
Good morning, Mr. Murphy.
Good morning.
You left Ropes and Gray in 1999, is that correct?
Yes, sir.
And then from that point on to the present, you've been primarily engaged in the work of either sports management or sports agency. Is that a fair thing to say?
That's correct.
Okay. Now, after you left the practice of law in Massachusetts at Ropes and Gray, was it your testimony that you did not participate in the practice of law anywhere else, including California and Massachusetts?
Yeah, no, I think, yes. I mean, I was not an active...
Okay. And in fact, it was the text messages that prompted you to contact Ropes and Gray, correct?
Yes, sir.
And that was because you were concerned, both for Mr. Hernandez as a client and as Mr. Hernandez as a person, that there was an individual who was threatening a potential lawsuit, correct?
Yes, sir.
All right. And that not only was he threatening a lawsuit, he was threatening to, quote-unquote, take all of Aaron's money, correct?
Yes, sir.
Or something along those
Yes, sir.
lines.
Yeah.
Now, you never intended to represent Mr. Hernandez in connection with any civil lawsuit should there have been one filed, correct?
Not by myself, no, sir.
Okay. When you say not by yourself, no one in your practice was going to represent Mr. Hernandez in connection with a civil litigation, correct?
Well, not by themselves, no. We
Well-
do it all as part of a team.
Was anyone in your practice at Athletes First intending to represent Mr. Hernandez legally in connection with any civil lawsuit being threatened by Alexander Bradley?
Well, yes.
Who?
Well, that's why Mark Humanick and I called Mr. Bradley's attorney to begin with, was to try to find out why he was, what the basis of his lawsuit was, what his intentions were, what he was trying to do, what he wanted. So we were representing him in that capacity during the whole phone call.
So Mr. Humanick was planning or intending to represent Mr. Hernandez throughout any civil litigation brought by Mr. Bradley?
Throughout the whole litigation?
Yes.
I think he intended to be part of that team. Yes, sir.
Well, you ended up turning over the entire civil litigation to Ropes and Gray, correct?
We referred Aaron Hernandez to Ropes and Gray to be part of his legal team because the nature of the text messages was certainly beyond the capacity of myself and Mr. Humanick. So Aaron needed more attorneys to handle that situation.
So when you had the conversation with Mr. Bradley's attorney, how did you introduce yourself on the phone?
I don't remember that.
Well, you certainly didn't say that you were Mr. Hernandez's attorney, did you?
Did I personally say that? No.
Did you know whether Mr. Humanick introduced himself as Mr. Hernandez's attorney for purposes of any civil litigation?
I would assume Mr. Humanick,
I'm asking whether you remember, sir.
yes, he did.
He did.
Yes, because Mr. Humanick would want to make sure that these conversations were part of the settlement privilege, protected by the settlement privilege.
And your testimony in direct examination that was, regardless of whether you were able to resolve the settlement issue, it was your intention to turn the matter over to Ropes and Gray. Isn't that correct?
Yes, sir.
Okay, and that was for purposes of handling the civil litigation,
Yes, sir.
because you felt that Ropes and Gray was better equipped to handle the civil litigation than your practice was, correct?
Absolutely.
Okay. And was Mr. Humanick a practicing attorney at the time that this was going on?
Yes, he was.
And was he practicing in what area?
I was an active member of the California Bar, and he practiced in whatever areas our clients needed him to be.
Okay. Did he perform any civil litigation on behalf of any of your clients?
What do you mean perform?
Did he go to court and represent any of your clients in any civil litigation?
That I do not know.
Now, in April of 2013, you received a letter from Ropes and Gray basically outlining the nature of the representation, and that letter also included an understanding of your role in the defense team on the civil litigation. Is that correct?
Yes, sir.
And that was a letter to you from Michael Fee?
Yes, sir.
All right. And your best memory is that although you intended to be bound by the letter, nobody ever ended up signing that letter, correct?
I don't remember my memory is not that we didn't sign it. My memory is I just don't know if we signed it.
So you have no memory whatsoever of whether you signed that letter?
I do not.
Okay. When Mr. Hernandez forwarded you the text messages from Mr. Bradley, am I to understand that that took place sometime before April? Is that correct?
I believe so.
Okay. Can you estimate for us more specifically when that took place?
I cannot.
All right. What was your reaction, or what did you say to Mr. Hernandez when he forwarded you those text messages?
Oh, what was my reaction, or what did I say to him?
What did you say to him?
What he said to him. Attorney-client privilege grounds.
I'm sorry?
Partly on attorney-client privilege grounds, which is why we're here. Hate to create another issue.
If this is a statement that Mr. Murphy made, then I don't find that it would be protected if it is before any meeting with Ropes and Gray. The meeting with Ropes and Gray, as I understand it, is in April. Is that right?
Yes, sir.
And you're asking about a conversation before that meeting at Ropes and Gray?
Correct, Your Honor.
Do you understand that, sir?
Yes, sir.
Okay.
Did you say anything to Mr. Hernandez when he forwarded you the text messages from Mr. Bradley?
I did.
What did you say to him?
I instructed or advised Mr. Hernandez not to respond to the text messages and to let the lawyers handle the situation.
Okay. When you say let the lawyers handle the situation, what did you mean by that?
Well, you got to understand, I got these text messages that were, as you've seen them, are incredibly unusual for a text message in my life, or probably your life. And I had no idea what they meant, what they were about, where they're coming from. And so when I said let's let the lawyers handle it, the way we do it at Athletes first step is to bring it to Mark Humanick, who's our general counsel. And then if Mark Humanick can handle it himself, great. He'll handle it on behalf of the attorneys, on behalf of the clients. If he can't, if it's beyond the scope of his expertise, or if more attorneys are necessary, then we'll hand it over to a law firm, whether it's Ropes and Gray or one of the multiple other law firms that we use.
So when you said let the lawyers handle it, you specifically meant Mr. Humanick?
No, I meant let the lawyers handle it. And again, I just got these text messages, and I had not absorbed them. I did not understand the nature behind them or the severity behind them. I just had these text messages that were very atrocious in nature. And so yes, the first step was Mr. Humanick, and then if we had to go beyond that, we go beyond that. But I did not want Aaron handling it because he's obviously not an attorney, and that would not be a good idea.
Well, I'm asking you where the lawyers came from. You said let the lawyers handle that. There had been no communication with Ropes and Gray at that point, correct?
Correct.
All right. So when you said let the lawyers handle it, you were specifically talking about Mr. Humanick? I'm just trying to clarify.
No.
Who were you talking about then?
Well, I just said that twice. When any one of our clients finds himself in a legal situation, right, our practice, our philosophy is to let the lawyers handle it. Now, the lawyers, if it's a drunk driving incident, it's going to be one set of lawyers. If it's a criminal nature, it's going to be another set of lawyers. If it's a breach of contract, it'll be another set of lawyers. Or it could be just Mark himself. So when I said let's let the lawyers handle it, I didn't have any specific lawyers beyond Mark Humanick in mind, but certainly given the graphic, the nature of these text messages, I had someone in mind. Did I know it was going to be Ropes and Gray at that time? Absolutely not.
So when you said let the lawyers handle it, that was some sort of generalized expression to basically say let somebody other than me handle it?
No, it was, Aaron, you don't handle it.
Okay, so that was designed to convey to Mr. Hernandez, I don't want you handling it, I want somebody else handling it.
Yes, sir.
Okay. Now, what was the result of, did Mr. Humanick get pulled into this, and did he, was he shown any of the text messages to your knowledge?
I believe he was.
Okay, and what was the result of that?
The phone call with Mr. Bradley and his attorney.
Okay. And your testimony on direct was the purpose of that phone call was to determine whether there could be some kind of settlement short of litigation, correct?
That was part of it, sir, but the other part of it was to just find out what was going on. As
Okay.
you can imagine, it was a very bizarre set of text messages, and we just didn't understand what was going on, so we wanted to figure that out.
What did you find out was going on as a result of the conversation?
Pretty much that Mr. Bradley was threatening to sue Aaron for a bunch of acts that he claimed alleged Aaron had done, and that there could be a monetary settlement if Aaron wanted that.
And did you determine that a monetary settlement was in Mr. Hernandez's best interest at that time?
At the end of that conversation, what we determined was, as I mentioned before, that we had to turn this over to attorneys who do this all day, every day.
Okay. So you made one phone call to Mr. Bradley's attorneys to find out, quote unquote, what was going on, and to determine whether there was a mutually agreeable possibility of a financial settlement, correct?
And also the timing of everything, sir.
The timing of everything, okay. And that was the sum and substance of your conversation. That is your conversation, Mr. Humanick's conversation with Mr. Bradley's attorney, correct?
That's a brief summary of it, yes, sir.
Okay. And immediately after that, you determined that Ropes and Gray ought to be brought in to handle this matter going forward, correct?
Yes, sir.
Okay. And at that time, you did not know, correct, whether a suit was actually filed?
During that phone conversation?
During that phone
During the
conversation?
phone conversation, to the best of my knowledge, I do not believe a suit had been filed.
So there was no pending civil action, as far as you were concerned?
I mean, pending? Yes, there's pending. It had not been filed, but it was, I mean, he was about to file it or wanted to file it, so
There was no case?
it had not been filed, yes, sir.
Now, you mentioned that there was a meeting at Ropes and Gray. Can you tell us who was in attendance at that meeting?
Well, Aaron certainly was. Robert Jones, who was a litigator at Ropes and Gray, was there. Michael Fee, another litigator at Ropes and Gray, was there. And I was there. I do not recall if anyone else was there. I don't recall if Mark Kunick was there or not, or if any other person from Ropes and Gray was there. I don't remember that.
And your testimony on direct examination was it was at that meeting that members of Ropes and Gray advised Mr. Hernandez to turn over the telephone that contained the text messages from Mr. Bradley. Is that correct?
That's my best recollection, yes, sir.
Okay. And you filed an affidavit in connection with this case, did you not?
I did.
Okay. And you did not mention that in your affidavit, namely that Ropes and Gray had advised Mr. Hernandez specifically to turn over the phone to them, correct?
That's correct.
Okay. And you testified in the grand jury in connection with this case. You never mentioned in the grand jury that Ropes and Gray had advised Mr. Hernandez to turn over his phone to them, correct?
Correct. I don't think anyone's asked me that question before.
Okay. Did you ever, is it your recollection that the only time that a discussion about what to do with that phone ever came up was at Ropes and Gray at a meeting with you, Mr. Jones, and Mr. Hernandez?
So to give you the whole answer, to make it so I can clarify, Aaron forwarded me the text messages. I told him we should turn it over to the lawyers as we discussed. Had the phone conversation with Bradley and Mr. Bradley and his attorneys, then had the meeting at Ropes and Gray. I believe the first time anyone talked about the phone or turning it over to Ropes and Gray was at that meeting. It could have occurred a day or two before if the Ropes and Gray lawyers made that suggestion at that point, but I'm almost positive it was at the meeting. And it was definitely the Ropes and Gray attorney's idea to turn over the phone. That was not my idea.
Okay, well, perhaps I misheard you. I thought I heard you to say just now that when Mr. Hernandez showed you the text messages that you advised him to turn it over to the lawyers.
Yes, not the phone, to turn the whole litigation over to the lawyer. So again, he didn't show me the text message, he forwarded them to me, and I said, don't respond to the text messages, and I'm sorry, turn this matter over to the attorney, not his phone.
Okay, but you thought it was important for the lawyers to know what was contained in those text messages, wouldn't you agree?
Yes, but they wouldn't need the phone for that.
Okay. Well, Mr. Hernandez or you could have easily taken pictures of the screen or paraphrase what was on the phone, but the point is that the information, that is the threat by Mr. Bradley to Mr. Hernandez, did you think that was something that was important to pass along to the attorneys?
The information?
Yes.
The language of the text
Yes.
messages? Yes, sir.
Did you ever say that to Mr. Hernandez, that maybe you ought to pass this information along?
The text messages themselves?
The information in the text messages themselves, anything having to do with Mr. Bradley, you never advised Mr. Hernandez that that might be a good idea to forward on to the attorneys?
Oh, of course I did. How,
Okay.
how else would they represent him?
So you did. Okay. So you advised him in your capacity at Athletes First that he should probably turn those over to whoever those lawyers end up being. At the time, it wasn't Ropes and Gray because you hadn't contacted them yet, correct?
Yes, to be clear, I never advised Aaron to turn the phone over to anyone.
I understand that. That's not my question. Did you ever advise Mr. Hernandez to turn over either the substance or a summary of what was on the phone to, quote-unquote, the lawyers?
I told Aaron that I would be the conduit for that information, that I would pass on the information to the Ropes and Gray attorneys in preparation for the meeting that we're going to have with Aaron so they could decide to represent him.
I guess my question, Mr. Murphy, was there a conversation about the substance of the text messages prior to the meeting at Ropes and Gray between you and Mr. Hernandez?
Oh, I'm sorry. There's probably a brief conversation about the substance, and then just hand it over to the attorneys at Ropes and Gray. I'm sorry, I misunderstood you.
That's okay. Now, Mr. Murphy, prior to going, when you arrived at the grand jury, now, if I told you that your grand jury testimony was in March of 2014, you wouldn't have any reason to not believe me on that.
That's correct.
Okay. So when you showed up in March of 2014, you arrived at the grand jury and you had Mr. Butters with you, correct?
I did.
Okay, Mr. Butters was representing you in connection with your appearance at the grand jury.
Yes, sir.
All right. And how long, when was it that you retained Mr. Butters to represent your interests at the grand jury?
So I don't know that.
Okay, was it months in advance, weeks, days, any?
Months would be my best guess, but I really don't know.
Okay. And how did Mr. Butters come to your attention? Was he referred to you? Did you know Mr. Butters? Did you have some sort of professional relationship with him beforehand?
No, sir. I believe he was referred to me by one of Aaron's attorneys.
Okay. Now, when you arrived at the grand jury with Mr. Butters, you met Mr. Hagan, the lead prosecutor in this case, correct?
I did.
Okay. And there was discussion prior to you going into the grand jury regarding the parameters of your testimony. Is that fair to say?
That I remember having conversations with Patrick and Mr. Butters, but I don't remember exactly what we talked about.
Well, are you saying that you did not know that what portions of your proposed testimony in the grand jury would or would not be covered by the attorney-client privilege?
By the attorney-client privilege?
Yes. You had discussions, did you not, with Mr. Butters and Mr. Hagan, or there were discussions, I'm not necessarily saying that you participated in them,
Sure.
but there were discussions regarding the limits of the questions that were going to be put to you in the grand jury, correct?
Objection, foundation.
How so, sir?
Witness just said he didn't remember. Counsel rephrased the question and asked generally, well, you know that some discussions occurred. It's not clear how he knew, whether he knew. There's no foundation for this witness to answer it based on his own knowledge.
Overruled.
Sir, I recall discussing with Patrick the topics that I would be talking about at the grand jury and the different issues that I'd be asked about. And part of that conversation may have included a discussion of the attorney-client privilege. I do not remember that part of the discussion, and like you said, it was a discussion mostly between the attorneys. But my conversations with Patrick were, what I do recall is him telling me, I'm going to ask you about this topic, that topic, this topic, this topic.
Okay.
So we may have talked about it, I don't remember that part.
Well, isn't the whole reason Mr. Butters was there to advise you on the substance that may or may not fall under the attorney-client privilege?
Well, no, Mr. Butters was there because I was called in front of a grand jury and I thought it would be a good idea to have an attorney with me.
Why?
Well, I'd never been called before the grand jury before, and I thought that...
Well, you didn't commit any crimes. You weren't under investigation, were you, Mr. Murphy?
No.
Okay. So Mr. Butters was there because there was an issue about whether things that you may have said to Mr. Hernandez may or may not have been covered by the attorney-client privilege. You don't remember that, sir?
I don't remember that, no.
You don't remember Mr. Butters having conversations with Mr. Hagan about the limitations on the questions, specifically as they related to conversations in which Ropes and Gray attorneys may have participated? You don't remember any of that?
No, I don't, sir.
Now, as you testified just a few minutes ago on cross-examination, your best memory was that nobody ever asked you whether you had provided any advice to Mr. Hernandez about turning over the phone, correct?
I believe what I said was, no one ever asked me who told Aaron to turn over the phone to Ropes and Gray lawyers.
Okay.
So basically the same.
And when you were asked in the grand jury about those text messages having to do with Mr. Hernandez turning over the phone, that is the text messages from June of 2013, Mr. Hagan was asking you to give some context to those text messages in an effort to identify whether the phone that was being referenced in the text messages was the phone that contained those text messages, correct?
You lost me on that one, but
Okay.
sure.
You were asked what those text messages mean, correct?
So just to confirm, and this is in June now?
The text messages that you had with Mr. Hernandez while you were in church regarding the turning over of the phone to Ropes and Gray, you recall those text messages?
Okay, so I'm sorry. So we're not talking about the April text messages anymore?
Correct.
Now we moved to June. And if you show me them, it might help.
Court Your Honor.
You may.
Thank you very much. All right, so just to help me look at this document, when you say, when it says Aaron Hernandez in the left-hand column, and it says just sit down at church, that means that's my message to Aaron Hernandez?
Correct. That's
not his message?
In the left-hand column would be the recipient.
Recipient, okay. And so this is a June. Okay, so I see these text messages.
Okay. And just to And just to be complete, Mr. Murphy, showing you the first page of other text messages
Thank you.
that are not part of my question, but they have a sticker up on the top there. It says Grand Jury Exhibit number 77. Do you see that?
Yes, sir.
Okay. So that two-page document, referring you back to the second page, do you recall being asked in the grand jury basically what the substance of those text messages meant?
Yes, sir. I'm a little confused by the June date, but yes, sir.
Okay. But leaving aside for a moment the date of the text messages, your testimony in the grand jury was that Mr. Hernandez had informed you that he turned the phone over to Ropes and Gray. That's in effect what's going on in that text message. Is that correct?
Yes, sir. That would be, when he said nope, just say in, drop phone off. That's what I would assume what that meant.
Okay. Well, you were asked specifically what that meant in the grand jury, were you not?
Yes, sir. That's what that
And your
meant.
response was that that was a reference to Mr. Hernandez dropping the phone off at Ropes and Gray, correct?
Yes, sir.
Okay. Mr. Murphy, prior to going in to testify in the grand jury, I believe you may have referenced this before, you had a conversation with Mr. Hagan about the questions that he was going to ask you. Do you remember that?
Yes, sir.
Okay, so he was going to tell you, this is the subject matter I'm going to cover, and these are the questions I'm going to ask.
Yes, sir.
Okay. And do you recall Mr. Hagan saying at the end of that to both you and Mr. Butters, whether you understood and were satisfied with the questions that were going to be asked of you in the grand jury?
Yes, sir.
Okay. And did either you or Mr. Butters lodge an objection to any of the questions that Mr. Hagan was proposing to ask you in the grand jury?
No, sir.
Okay. And nor did you or Mr. Butters say anything during the actual questioning within the grand jury, correct?
Not that I recall, yes, sir.
You never asked to consult with Mr. Butters, and Mr. Butters never asked to consult with you during the questioning in the grand jury?
Not that I recall.
So, Mr. Murphy, in the affidavit that you filed in connection with this case, and I understand that you filed two almost identical ones with some minor changes between the first and the second, correct?
Yes, sir.
Okay. And in those two affidavits, in at least the one dated January 21st of 2014, you stated that you had not had any communications with Mr. Hernandez prior to June 17th, 2013, relative to disputes or altercations in which he was allegedly involved, including the shooting of Alexander Bradley. Do you remember writing that in the affidavit?
Yes, sir.
Okay. And that's not true, is it?
Well, it's not. I think that's why we revised the affidavit.
Okay. Well,
Thank you.
I want to refer you specifically to paragraph number 5 in the affidavit dated January 21 of 2014.
Yes, sir.
Okay. And paragraph number 5 is not correct or not true, is it?
I'm sorry, under which affidavit?
January
Jennifer
21, 2014, paragraph number 5, the last paragraph.
I would say if I had those text messages in front of me again and saw the date, then that would probably be not true.
Okay. So I did not have any communications with Mr. Hernandez prior to June 17, 2013, relative disputes or altercations in which he was allegedly involved, including the shooting of Alexander Bradley. Well, we know that's not true because you talked about conversations you had with Mr. Hernandez as early as April regarding Alexander Bradley, correct?
When were the text messages forwarded to me from Aaron?
June 10th and 11th of 2013. Well, there's two sets of text messages. There's the text messages from Mr. Bradley, but that's what I'm asking you is when you say that you did not have any communications with Mr. Hernandez prior to June 17th, 2013 regarding Mr. Bradley, that's not true.
Correct.
Okay. And then that was an affidavit you filed in January 21st of 2014, and then you said that because of that, you filed a revised affidavit, and now referring you to the revised affidavit of February 13th, 2014.
Yes.
And in that one, you said that you did not have any communications with Mr. Hernandez relative to disputes or altercations in which he was allegedly involved, including the shooting of Alexander Bradley, correct?
Correct.
Okay, now that doesn't even have a date restriction, but that's also untrue.
Well, no, and I apologize for my earlier answer. I mean, what I talked to her about with your colleagues was when I filed this affidavit, the meaning behind the affidavit was that I did not sit down with Aaron and talk to him about the alleged incident where where someone shot Mr. Bradley or where he was down in Miami, the whole incident. I never talked to Aaron about that. I got a text message from him where he was being sued about it. And I talked to him about those text messages and about how he was being sued, and I was pass it along to the attorney. But again, not being an attorney and not being my role as a sports agent, I never specifically discussed with Aaron the details relative to the disputed altercations. And that's what, when I was called to testify in front of the grand jury, that's what I explained to your colleagues, and that was what both sides understood that to mean.
Well, the statement in paragraph 5 is, I did not have any communications with Mr. Hernandez prior to June 17th, 2013, relative to disputes or altercations in which he was allegedly involved, comma, including the shooting of Alexander Bradley. Are we to understand that that means that the only thing that you meant by that was I didn't talk to him about the facts underlying the case?
Yeah, well, as I explained to you, not you, but your colleagues, because you weren't there right before I testified at the grand jury, when I did have conversations with them, I explained to them exactly what I meant by that sentence, and we agreed that it could have been written better and it could have been could be interpreted differently. But I think we came to a meeting of minds as to what I meant, because they didn't have any problem with it at that time.
Okay, so you revised it on February 3rd, and the only thing you took out was prior to June 17, 2013. Otherwise, the statement is the exact same.
Right, and again, because I explained what I meant by this statement, there was no need for a date. You're not.
I understand that, but what you're saying is that you did not have on the February 3rd affidavit, the statement now becomes, I did not have any communications with Mr. Hernandez relative to disputes or altercations in which he was allegedly involved, including the shooting of Alexander Bradley. That's not true.
No, that is true, and that's what I explained to your colleagues.
You never spoke to Mr. Hernandez about anything having...
Objection, Your Honor. The witness finished his answer.
Had you completed your answer?
No, sir.
You may.
Yeah, again, as you know, being an attorney, you can read words in many different ways. There's many different interpretations. When I sat down with your colleagues before testifying in front of the grand jury, I explained to them what I meant by this statement. Okay?
Well, explain it to us here, what you meant by that first statement.
Sure. I did not have any communications with Mr. Hernandez relative to disputes or altercations in which he was allegedly involved, including the shooting of Alexander Bradley. What I meant by that, as I explained before the grand jury testimony, is I have never talked to Mr. Hernandez about whether he was involved with the shooting, about the shooting itself, about who may have done the shooting, or about where was Bradley, those are conversations that I did not have with Aaron, because that's not really what I do as a sports agent, okay? Now, that's what I meant by it, and that statement is 100% true based on that interpretation. I also understand, as your colleagues explained to me, that they could read it differently. And I explained to them at the time that under their interpretation, yes, obviously that's not true. You could based on the text messages between me and Aaron. So under one plausible interpretation, this would not be a true statement. Under another plausible interpretation, it is a true statement. And when we talked about it at the time, we agreed to change it as I did, and to make it more so we both understood what was being said.
I suppose my confusion, Mr. Murphy, comes from the fact that the only change from January 21st to February 3rd is the omission of the date. Otherwise, the language is identical.
Correct.
Okay. So in an effort to clarify, why would you use the exact same language that you employed before?
Because once I explained what I meant by the language, the date was no longer necessary.
Well, the date was putting a limitation on when you had the conversation. When you take the date out, there's no limit. So what other than the date, the words that you used in the second affidavit are identical to the words you used in the first affidavit.
Correct.
And that was your version of clarifying for the prosecutors what you meant.
Yes, sir.
Thank you, Mr. Murphy.
Thank you.
Mr. Sullivan,
Thank
please
you.
redirect.
Thank you, Your Honor. Let's start where they left off with the infamous paragraph 5. Were you intending to mislead anybody with that paragraph?
No, sir.
and you said you talked to counsel's colleagues about the paragraph. Who specifically?
I talked to Mr. Butters and Patrick.
And by Patrick, you're referring to Mr. Patrick Hagan?
Yes, Mr. Hagan, yes. Sorry.
And just for purposes of the record, not
No,
empty formality.
No.
But so Mr. Hagan, did Mr. Hagan express any concern with the revision?
Mr. Hagan expressed concern with the way it was originally written, and I explained to him what I meant by those words. And then after we revised it, I didn't have any. Mr. Hagan didn't express any concern with that.
Was that the only revision between January and February?
I believe so.
Was to eliminate a date?
Yes, sir.
What was the purpose then for a revised affidavit?
And again, I haven't read through the entire affidavit, but I believe that's the only revision. And if it wasn't, I think they would have mentioned it. The purpose again was the way I wrote the words. That I've never talked to Aaron about the actual incidents and what happened. There was no reason to have a date. I've never talked to Aaron about that. So that's the date was confusing because it implied that after that date I had talked to Aaron about it. And in fact, I've never talked to Aaron about, what happened in Miami.
And drawing your attention to my initial direct examination of you, you did talk to Aaron about other matters related to the incident, specifically the civil litigation.
Yes, sir.
You talked to him about the text messages,
Yes, sir.
the telephone.
Yes, sir.
Just three more areas, Mr. Butters, and we appreciate your time and traveling. On cross-examination, counsel referred to the pattern and practice of your firm with respect to athletes who may find themselves in some sort of legal trouble. You answered that series of questions by saying that saying that whether it's a DUI or whether it is an assault, clients will come to you, you will engage, or your associates, you will engage the general counsel and then determine how best to satisfy their legal needs. Do you remember that question, those questions and answers?
Yes, sir.
Now, is that the traditional pattern at Athletes First?
Yes, sir.
So, do you recall the questions with respect to turning the matter over to other lawyers?
Yes, sir.
Now, when you say turn the matter over to other lawyers, did you mean by that you put all the papers in a box, send them over to lawyers, and never have any communication again?
No, sir.
Were you actually referring to a team approach with respect to matters that you may not have been, your firm may not have been sufficiently resourced for?
Absolutely.
Can you explain how the team approach would traditionally work?
Sure. I mean, it's actually Athletes First. Our business philosophy in every aspect of our business is a team approach. And in this particular case, or any legal case, if a client gets in trouble with the law, he'll go to his agent, his agent with whom has the best relationship. For Aaron, I was a certified agent, and we had the closest relationship. And then I would bring in our general counsel, who's an expert in being a general counsel. Right, that's what he does all day, every day. And then if we can handle it ourselves, if it's a relatively small matter, we will. If it's a bigger matter, like you said, a DUI, or in this case, more serious charges, then we're going to bring in a law firm of experts who can give our client the very best representation. And we don't turn it over, say, hey, Aaron, now you're in Ropes and Gray's hands, good luck. We work actively as a team, because at the end of the day, Aaron's part of the Athletes First family, and he's part of one of our clients, and we have to do what we want to do, what's best for him, and we want to make sure he's got the very best representation. And you can't achieve that by simply turning it over. You have to work as a team, particularly because we know Aaron better than any other law firm would know Aaron. So that's our approach across the board, not only with Aaron, with all 100 plus of our NFL clients.
And when you work as a team, do you consider the areas discussed with respect to whatever sort of litigation or case, do you consider those to be privileged?
Yes, sir.
And did you, with respect to Mr. Hernandez's situation?
Yes, sir.
One last area. At any time did Mr. Hernandez waive the attorney-client privilege?
No, sir.
At any time did Mr. Hernandez come to you and say, Mr. Murphy, you can talk about all of our conversations. I waive any interest I have in these conversations being protected?
No, sir.
Is it your understanding that you hold the privilege or that Mr. Hernandez holds the privilege?
Mr. Hernandez.
The objection's overruled. The answer may stand.
Your answer was?
Mr. Hernandez holds his attorney-client privilege. It's not mine to waive.
So whether you were asked about the privilege beforehand, did you have the ability to make a decision about waiving the privilege?
No, sir. That's not my decision to make.
Now, last a couple of questions here. So when a client comes to you about initial legal trouble, you've testified that you bring in general counsel and perhaps other lawyers, depending on the situation, right?
Yes, sir.
I want to focus your attention on that point in time when a client initially brings a matter to your attention. Right? So let's just say a DUI, for example.
Yes.
Client says, I've got this DUI. All right, so you don't then go and blog about, for example, your client getting stopped the night before.
Do I blog about it?
Right.
No, sir. I do not blog.
You consider those conversations to be confidential, don't you?
Yes, sir.
And that's why you start bringing in a legal team.
Correct.
When Mr. Hernandez brought you a telephone or sent you text messages that threatened a lawsuit, did you consider him approaching you as his agent to get advice, including legal advice, about how to proceed?
That's why he sent me the text messages, so I could give him advice.
Nothing further, Your Honor.
Is there a distinction in your mind between confidential communications with one of your sports clients and the attorney-client privilege?
Yes, sir.
You see a difference between those two?
Yes, sir.
So if one of your sports clients calls and tells you, I just got popped for an OUI, would you consider that to fall under the umbrella of your agency confidential relationship? Or would you consider that an attorney-client communication to you?
Well, because I'm not a practicing attorney, I feel that if someone calls me and says, hey, I have a OUI, I feel that they're coming to me for advice for me to turn it over to my attorney, but I don't think me and the agent...
They're calling you as their agent,
Yes, sir.
not as their attorney.
Yes, sir.
Okay. Anything further? Mr. Lee, any recurse?
Very briefly. Mr. Murphy, you said you considered, in response to some of Mr. Sullivan's questions, that you considered the communications between you and Mr. Hernandez to be protected by the attorney-client privilege. You remember saying that on the redirect?
What communications?
The communications between you and Mr. Hernandez.
All communications?
No, the communications that Mr. Sullivan was discussing relative to the phone, the turning over of the phone.
Yes, sir.
Okay. And yet you answered all the questions put to you in the grand jury by Mr. Hagan, correct?
Yes, sir.
And you did not say, I believe my answer to this question is protected by the attorney-client privilege, correct?
Yes, sir.
Nor did Mr. Butters.
Yes, sir.
And you were asked prior to going into the grand jury whether the range of questioning by Mr. Hagan was satisfactory to you and Mr. Butters, and you told him that they were satisfactory, correct?
I don't think anyone asked me if they're satisfactory, but they could ask me whatever I want. It's for the grand jury. But
so
We discussed what was
your
going on.
feeling is that you can be asked whatever question anyone wants to ask you in front of the grand jury?
well, no, I have an attorney to protect me from that.
Okay. And you never once consulted with him, did you?
No, sir.
Okay, and nor did he with you?
He did not. Yes, sir.
Thank you.
All right, anything further? You may step down. Thank you.
Thank you very much, sir.
Watch
Good day.
yourself, please. Mr. Sullivan.
Thank you, Your Honor. We submit that we have met our burden in terms of raising the issue of the attorney-client privilege being pierced in the grand jury testimony. And there are three theories, each independently
Before you get to
satisfied.
argument, let's see if the evidence is closed.
Oh, I'm sorry, Your Honor. Yes, as I represented before, we only have the one witness. I'll say for the record, we filed a motion to suppress, and there are addenda in the record.
All right, that's what I want to address. I've had live testimony from one witness that you have offered. Supporting the motion to suppress were 12 attached exhibits listed as A through L.
Correct.
Are they part of the record for purposes of my ruling?
Yes, Your Honor. I'm happy to make a formal motion and move them in evidence, but I think they're part of the record.
You consider them part of the
I
record?
consider them part
All
of the
right,
record.
let's see if the Commonwealth does.
Your Honor, I note that one of those, I believe, is an affidavit. At least our copy was unsigned by the defendant, and I don't believe that that would be considered evidence.
I believe that we
Think so.
received a signed affidavit.
But
Yes, we
I
did.
bet there's one in the record, I just note that.
In the original court pleadings, a signed affidavit was submitted in December. So that is before me. Now, as to everything else, the grand jury transcript, bar status, the Rosenberry letter, Mr. Butter's affidavit, is there any objection to all that being part of the record evidence for this hearing?
I would object, Your Honor, the affidavits are not evidence, probably to be considered by this court. The affidavit may have sufficed to bring us to an evidentiary hearing today, but it's now counsel's burden to present evidence in the form of live testimony, not through affidavits.
Is that all you're objecting to, or affidavits?
I'll withdraw the objection to all the affidavits.
All right, now one missing or two missing affidavits were just referenced. You did not attach the affidavit that Mr. Murphy had prepared, either in January or the revised affidavit in February. No one's offered that as an exhibit before me.
To complete the record, it should be an exhibit.
Well, someone has to offer it.
So we will move for both of the affidavits to be entered into evidence.
Any objection?
No objections to the affidavit, but
Does
to,
anyone have it?
well, Your Honor, to the ones that were presented to the witness, we do object. There was writing on there. There's some form of piercing.
I take it I'd receive it without writing.
Very well.
All right. Ms. Anderson, you have clean copies, or you obtaining them?
Yes, we do have these copies, Your Honor.
The affidavit dated January 21, 2014, to be Exhibit 1. And the affidavit affidavit dated February 3, 2014.
All right, Ms. King, I'm going to hand you a list of items that are marked A through L, and let's make them succeeding exhibits 3 through 14.
Yes, sir.
That's, all right, counsel, I'm going to take a brief recess while these get marked, the various exhibits that were attached.
Very well. All right, please.
You may be seated.